Good evening and welcome to this evening's webinar, BMWED Claims and Grievance Arbitration. I'm Ash Anderson, your Director of Education. I am joined by a few other panelists this evening. Alex Cruzy from our Legislative Department, John Schlissman from our Arbitration Department, and Brother Zach Wood from our National Division, our Director of Strategic Coordination and Research. Right now, you can't see them because you see the presentation, which we will get through. That will help give you the key terms and concepts to sort of frame tonight's discussion and give you more information about the claims and grievance process. However, after the presentation, if you do have specific questions, you should feel free to take part in the discussion with our panelists. And that way we can all get a good understanding of the topics we're discussing tonight so that you can go back to your members and share that information. The presentation tonight discusses key terms and concepts regarding claims and grievance arbitration, just as I said before. However, I want to make sure that we all understand no panelist in this event this evening can discuss specific claims or cases. If you have a specific issue on a specific claim that you might be on that's in arbitration, that is a question for your general chairperson. It is a question that we don't have the information to answer tonight. We will be able to give you information about the processes and the big picture issues surrounding arbitration of our claims and grievance process. For the very specific questions you might have, again, your best resource is your general chair. Our learning objectives for this evening include how arbitrators are selected, how arbitration is funded, what timelines govern arbitration once it gets into the arbitration process, how those arbitration cases are conducted, how BMWED, how our union determines what cases go to arbitration, what that looks like, arbitration awards and precedent, as well as a brief discussion of how the duty of fair representation can impact our arbitration work. Why does this matter? Well, this matters because this is the system we have to resolve minor disputes under the Railway Labor Act. Just recently, just last month, we had members on our National Division Facebook who were trying to say things about the arbitration process, but they didn't even know which board they were referring to, which board did the arbitration work. And then they were conflating railroad retirement issues under a completely different board, completely different governance with arbitration. And so this is an issue, right? Because we have to know the system we're discussing in order to be able to understand and improve it. And we got to make sure that our fellow members have that information as well. Commenters on that post started asking how arbitration could affect things with the NLRB, which doesn't apply to us, right? So that's something that we can clarify this evening. RRB, the Railroad Retirement Board, also has nothing to do with arbitration. And NLRB doesn't handle rail labor arbitration. These are all things that we're going to hope to clarify this evening so that our members are prepared with the facts about these issues and we can discuss them in ways that we can improve everybody's understanding and knowledge moving forward. Because to make a better system, we all need to understand the systems that we have in place now. And we teach each other. And so the information you get tonight may help you understand these issues for yourself. But as a union member, it's incumbent upon all of us to make sure that we spread this knowledge around. We just can't keep it in our pocket. That being said, let's talk about what we have now. If you have a claim or dispute about something regarding the interpretation or application of your bargaining agreement, it's going to be a minor dispute. And minor disputes are subject to compulsory arbitration under the Railway Labor Act, the RLA. This is the claims and grievance process writ large. A lot of that process is handled through what's laid out within your own collective bargaining agreement, the things that are handled by your vice chair, your local chairperson, and your general chairperson. However, once that process has reached its end, the process continues with arbitration at the national level. And that's what we're going to be discussing this evening. We're going to be discussing what the NMB, the National Mediation Board, is and what the National Railroad Adjustment Board within the NMB is. We're going to talk about terms like third division, public law boards, special boards of adjustment. We may not dive too deeply into each of these different concepts, but you'll be familiar with how they work within this general framework. And we're going to be talking about what is generally referred to as Section 3 arbitration based off of the section it occupied in the previous versions of the Railway Labor Act. So how did we get that? How did the RLA become the method by which we do all this, because we didn't always have it. After World War I, the railroads returned to private control under the Transportation Act of 1920. Now, it's important because during World War I, the U.S. government controlled the railroads, and they wanted to keep the railroads operating smoothly for the war effort. That wasn't going to be forever, even though there was a lot of discussion and thought and argument right after World War I about what was going to happen with the railroads. President Harding, when he was elected to office after World War I, made it pretty clear that he was going to return the railroads to private control, and they did that through the Transportation Act. Part of that act, they established a 9-member railroad labor board to resolve disputes between labor and management. That board, that 9-member board, was 3 members from labor, 3 members from the railroads, and 3 members from the public, ostensibly. What that board was, in all actuality, was completely useless. That board proved completely ineffective at resolving disputes, and it proved to end up being a creature of the railroads. They were able to really put their thumb on the scale for railroad management in a way that led to pay cuts and led to the absolute avoidance of resolving any sort of disputes that we had with management under the terms of the time. The RLB of the time approved successive wage cuts in the early 20s up through 1922 that precipitated the 1922 shopman strike, which was important because it was a really critical event in the Harding administration that demonstrated to the American public that the Transportation Act was just not working. That strike failed. The 1922 shopman strike, in the end, the U.S. government broke up the strike and basically forced everybody back to work. They worked pretty closely with rail management to get that done. And that's an entire history, an entire class of its own that I'm putting together. However, for our purposes, we need to know that the 1920 Transportation Act and the Railway Labor Board it created were replaced by the 1926 Railway Labor Act, which we know today, which we still operate within. This ended the ineffective Railroad Labor Board. What did they decide to replace it was at first a 5-member board of mediation, which was not the NMB. It was a different body, and it was not compulsory. So it could come up with recommendations to resolve disputes, but it didn't have any way to force compliance by the railroads or by rail labor. And so again, very quickly after it got passed, disputes just stacked up because the railroads could disregard the findings of this 5-member board of mediation. And we were going to get into the same position we were in before. Congress recognized the issues with that, among other issues of the time, and they amended the RLA in 1934. Part of those amendments in that 1934 package included the creation of our current National Mediation Board and empowering them with a ability to force compulsory arbitration for the minor disputes that were stacking up prior to this amendment. And part of that National Mediation Board, they govern minor disputes. They do a bunch of other work regarding labor and rail relations between us and management, with how we organize properties, how we bargain. NMB has their piece in a lot of that. But tonight we're going to be discussing what they do through their Office of Arbitration Services. And that's what we're talking about with claims and grievance arbitration. So that's how we got there. We started after World War I with a process they tried to enact through the Transportation Act. It failed. The earliest part of the RLA didn't work out. We got the 1934 amendments, which gave us the NMB and the NRAB we have today. But what does that look like? What is the structure of the NRAB, the Office of Arbitration Services, for us? On the screen now, you can see in a nutshell what the NMB looks like writ large. And you can see all the different offices they have within the NMB, not just arbitration. So they do legal affairs, mediation services, administration, information services. They do a lot of stuff. What we're interested in is the Office of Arbitration Services. Now, one thing we have to be aware of, and one thing we'll discuss later on this evening, is that when the National Mediation Board is a government-funded agency, when it gets its budget, that budget gets split up among all these different offices. It doesn't all go into arbitration. And so when we think about NMB funding, we have to think about where it's going. NMB requested $14.3 million, down $800,000 from previous funding, but the House Appropriations Committee House Appropriations restored that $800,000 and included language that directed NMB to use the funding to reduce the arbitration backlog. We'll be able to discuss more what that looks like with Brother Cruzy and our discussion around the funding piece, but I can tell you that this was also a direct result of BMWED efforts on Capitol Hill. And so that's something we can talk about later this evening. When we break into the Office of Arbitration Services, this is what gets us to the actual boards that resolve our minor disputes. We have the National Railroad Adjustment Board, the NRAB, and for BMW, the cases within our craft go to the third division. And so if you've ever heard about a third division case, it was NRAB third division, and that was the arbitration board for that. Also, depending on agreement between the union and the railroad, you may have public law boards, which are formed by agreement between the two parties that could expedite some cases, but they're not guaranteed to do so. And then there are special boards of adjustment, which can be voluntarily established again by both parties to handle very specific issues or large volume case questions. Most of the time when we think of arbitration, you're going to be thinking about third division. Now, your general may let you know if cases in your system, division, or federation are going to a PLB or if they're part of an SBA. Your general chairman will know where their cases are going, where your cases are going, but these are the options available. When we talk about each of these boards, so there's the PLB, NRAB third division, and SBA, they could be defined differently. They may have different agreements, but they have similar composition. A board for arbitration is going to be 3 members. It's going to have a union member, somebody from our union who is there to handle arguments or, present the case from our position. The carrier member. Now, the carrier member may come from a railroad or come from the National Railway Labor Conference, the same folks who, as the NCCC, take part in bargaining. And so that may be, again, something you'd have to understand. It's a case-by-case thing. We don't get to pick the carrier member. The carrier does. But between the union member and the carrier member, if they don't agree, then there is a third-party neutral arbitrator, somebody assigned to the case by the National Railroad Adjustment Board themselves, and who is intended to work with the other 2 members of that board as a team so that they all together can consider and resolve the dispute. Now, our union member, and with us this evening, is Brother John Schlissman. He is our current third division NRAB board member, and he'll be able to tell you from his perspective what this means, what it looks like, and where I messed up in this presentation. When we talk about the potential neutral arbitrators, who we're talking about well-regarded experts in their field, in law, in the arbitration industry. These aren't just folks they gather off the street. These are folks who are well-experienced, well-regarded folks who apply to become arbitrators. They have 1-year renewable terms. And so if you become an arbitrator, it's not just something that you get appointed and you're there forever. You have to continually renew your appointment as an arbitrator. And you do that by working with the National Mediation Board and the Office of Arbitration Services. To become an arbitrator, you cannot be connected to a union like ours, and you cannot be connected to a railroad. Neither can you be in a law firm that represents either railroads or rail unions, and you cannot be a government worker. Any of those 4 categories will prevent you from becoming an arbitrator because you're supposed to be truly disinterested, a truly neutral voice to help resolve the issue. Once you join on and become part of the National Mediation Board, NMB's roster of arbitrators, then there are several different ways you could be selected for a particular case. There is not one size fits all. It depends on what's happening. You can either be selected by agreement between the union and the railroad for some cases. If they cannot agree on an arbitrator, the parties may go to what's called a strike list, where a list of potential arbitrators are offered, and then the railroad and the union take turns removing names from that list until one is left. Or in some circumstances, the NMB will appoint an arbitrator to a specific case. Arbitrators don't get to pick their own work. It's not like they're picking kids at a baseball match, but they can accept or decline work they've been assigned. That gets kind of inside baseball, but it tells you in a nutshell what that process looks like at their level. Here next, we're going to get into some of the meat and potatoes, and I'll be joined for this portion by brother Alex Cruzy and other panelists, and we'll be discussing some of the funding and caseload issues that our arbitration department office in Mokina deals with, and our legislative department office in DC also works on to help make sure that this system works for our members as best as it can. When we talk about an arbitration case, big line items to know is that NMB pays an arbitrator $630 for each case they handle. That is what they receive as compensation for the work they put into arbitrating that case. That comes from government funding. It's funded through appropriations from Congress, and we discussed that briefly earlier. In 2026, the NMB requested $900,000 to compensate arbitrators for all types of case handling, not just our own union's cases. And so that's an important number to keep in mind as we talk about what the caseload actually looks like. On the screen, you can see a chart, and this is information I was able to gather earlier this year from the NMB themselves about their average caseloads. And you can see pending cases at this for estimated for 2025, estimated for 26, and their 5-year average. And so we're talking about thousands of cases are getting arbitrated through this process every year. And you can see a lot of cases end up going pending because the funding to hear these cases runs out. And if the funding runs out and they can no longer compensate the arbitrator, those cases just have to move on until funding becomes available again. They basically get waitlisted. When we talk about funding cases for arbitration, again, remember, the National Mediation Board does a lot of other work. It's not just arbitration. And so it's about 6% of NMB's yearly budget goes to actually compensating the arbitrators. You can see some of the other pieces of that big pie in this chart. That small green slice is the amount of funding that the NMB devotes to arbitrating our disputes and other rail union disputes every year. NMB also handles elections, mediation, not only for the rail industry, but also for the airline industry, bargaining, and presidential emergency boards. And so you can see other pieces of the pie go to other things. And of course, because the NMB has its own staff and its own officials, a lot of that also goes into their personnel budget. Well, this system wasn't intended to be a bottleneck. In all actuality, what's happened is you can see from the picture, all the rail unions, they all have cases that they want to get arbitrated, and it becomes a bit of a bottleneck to make sure that we can get all these cases heard. NMB estimates that they can close about 3,500 arbitration cases from all sources in, say, 2026. That includes party pay boards, which we can discuss later. BMWED cases would be a portion of that total. So understand if that's what they say they can do, we would get a piece of that total number of cases that BMWED can say, okay, we will have that. And there's no set number. There's nothing legislated. It depends on what their funding is, what their bandwidth is, what other unions are doing. It's a constantly shifting number, but the rough proportions are there. To look at that in a different picture, you can see that we have roughly 1,800 cases per year from all of our system divisions and federations. Other rail unions, some of them are larger than us. Some of them are smaller. Some of them may have more cases. Some may have fewer, but that gets added to our roughly 1,800 to become the total potential cases. Now, if the NMB only has funding for around 3,500 cases a year, they have to start doing math on how much they can accomplish. And if they can't hear every case, it will have to get waitlisted until funding becomes available. Brother Adam Gilmore from the arbitration office also sent me some of the latest information from Mokina about the cases that they're handling at our Mokina office. And you can see some files per month from various years here. In 23, we had 110 cases per month that the Mokina office was receiving and processing. And in 2026, just 3 years later, we've almost doubled that. And so our union members are submitting more claims that are getting processed on property, but then are getting progressed to national handling. It could be for any number of reasons, and we could all have our opinions on that. But understanding this is the sort of caseload that we have to manage because we know what the NMB and the NRAB would be able to handle on their end, and this is the math that we have to do. You can see again that here's another graphic from Brother Gilmore showing the files received per year. And this is rough. And you can see in 2026, we're still receiving cases. We're only a little bit over halfway through the year, but you can see where we're at. We've already received more cases in 2026 by August than we had in all of 2024. And so our members are getting better about submitting information to defend our rights under the agreement. And we are working hard at every level of our union to process these claims and grievances. But these are all facts that have to come up against the issues we face with the way the process is designed. This last chart from Brother Gilmore shows us some more information about files received per month. The green columns you can see in each of these months represents what we have in our most current year, 2026. And so you can see roughly comparing month by month between 24, 25, and 26, what our receipts have been looking like at Mokina. And we'll have folks be able to discuss these in greater depth. I know if Brother Gilmore or Brother Schlissman are on, you can also, if you guys want to talk a little bit about this more, feel free to comment now, or we can wait till the Q&A. All right. Moving on, we're going to be talking a little bit about funding cases for arbitration. Now, as I said before, NMB is funded through Congress by various appropriations. Unless consolidated in those sort of omnibus appropriations that we're all getting more familiar with, NMB funding is handled in the Departments of Labor, HHS, Education, and related agencies' appropriations bills. That's some sort of legislative technicality stuff, but if you want to know more about how that works on Capitol Hill, that's a better understanding of the process. When we're funding cases for arbitration, it's important to understand that the RLA was designed and the NRAB 3rd Division was designed to make sure that these cases were neutrally funded. Other cases, like certain public law boards, can have party pay, where the costs are split between the union and the railroad. This is done by agreement between the parties. Neither side can force party pay or a party pay agreement. It has to be mutually agreed upon. Party pay boards were intended and are designed to get around insufficient government funding, but they can also create conditions where the railroads basically try to bankrupt us because they have a deeper piggy bank than we do, and they can try to overwhelm us with cases in party pay boards. And so it's a strategic decision about whether a case goes to party pay or not. And that's made by your general chairperson and in conference with National Division leadership to understand what the strategy needs to be there. There is no hard or fast math that your case will go party pay or go neutrally funded. If you have questions about where your case might be, you should ask your general chairperson. Looking at the arbitration processes and timelines. This is where we talk a little bit, and this is where a lot of what I talk about is going to add on to whatever is already within your agreement. And so each agreement has its own process for resolving a claim or dispute. And it, with initial claim, with initial denial, appeal denial, it could go to a second round of appeals, going to a claims conference. All of those have timelines or time limits, usually a 60-day limit for most cases, but they all stack up on each other. And then we get past on property resolution and start talking about the arbitration process. And so understand that this adds on. Your general chairperson is ultimately responsible for handling your claim or grievance. That's another thing to understand. Our National Division Arbitration Department in Mokina, they assist and support your general chairperson in this work. They can't tell them what to do with the case. They can make recommendations, but they can't tell your general to do one thing or another with the claim that they are handling on behalf of you within your system, division, or federation. Previously, we talked about how many cases our arbitration receives, so we have the latest numbers on that. But when our arbitration department does receive a case, what they do is that they review that case for potential flaws that could hurt the success of that case, right? Those sort of fatal technical flaws that come about because this is an established procedure. There's established precedent about how these cases are handled, things about how evidence is submitted, what evidence is submitted, the way the case is argued. These are all things that come with training to handle claims and grievances at the property level. But when the Mokina office receives a case file from a system division or federation, they look through that record and they evaluate if there are any issues there which would cause that particular case to fail on some sort of technicality. They also research that case against other relevant cases or awards to determine what has been said about similar disputes by other arbitrators in previous awards or previous cases. In the Railway Labor Act, in the NRAB, the way we arbitrate, these aren't ironclad precedent, but they are very strong precedent. So that if an arbitrator hearing your dispute looks at similar disputes from the past, they will be strongly inclined to follow the reasoning of previous arbitrations on that similar issue. And so part of our job at the Mokina office is to look at all those previous cases to see how they stacked up in evaluation against the current issue and the arguments it makes. Once they've done all that, the arbitration office then recommends either that a case can progress, go get docketed and posted to be arbitrated, or they can recommend withdrawal of that case based off of issues they find with either its technical issues or merits or issues related to previous relevant cases or awards. These are recommendations. Your general chairman is still the decider on whether or not your case gets progressed. If it does get progressed, your arbitration advocates, also at the Mokina office, are the ones who write the formal submissions to get the cases docketed to the appropriate board, and that depends on the language within your agreements or with any other boards that may exist on your property. But the arbitration advocates in Mokina are the ones who will do all that write-up, do all that case analysis, so they have a ton of casework that they are dealing with. The broad process of on property will always generally end with what's called the denial by the highest designated officer on your railroad. That is what kicks off the timeline for the arbitration piece of it. And so it could go through all sorts of different channels, appeals, conferences. Prior to that denial, once that HDO denial is received, that begins the 9-month clock that this case has to be submitted to the appropriate board for arbitration. A lot of your on-property handling could also end up taking 60 days and 60 days and 60 days until you can start seeing how these timelines stack up, especially if the railroad is dragging its feet on meeting its time limits, waiting until the very last day to submit a denial or to submit its response to our claim. And so you can see how this clock could actually operate. In the 9 months prior to submission, so we got the HDO denial, 9 months might feel like a long time, but there's a lot more work that happens on that case before it gets possibly docketed. Your system in division or federation has to finalize the on-property record. It has to build the final case file that goes to our arbitration department. So there's a lot of correspondence, a lot of evidence, a lot of other things that get put together, put into a document that then gets transmitted to Mokina where it can get reviewed. And there's a certain format for that. You can talk to your system division or federation officers about what that looks like, and they can let you know. Those arbitration advocates in Mokina review the case file. They look for those technical procedural errors. They look for factual or evidentiary issues. They look for the clerical errors, anything that could cause this case to fail or to create issues down the road. They also research that relevant case or award history. And it takes time to do that research, right? If I told you to go off and find me facts at the library, it'll take you some time to look through all the relevant cases. And they have some systems in place to help them identify relevant case history, but there's still a lot of time that it takes to do that research. And that goes in that 9 months prior to submission. And then it also takes time to write those formal submissions. I don't think anyone joined their railroad or became a union member to become a full-time professional writer. Our folks in Mokina have stepped up to the challenge, but they do a heck of a lot of writing. It still takes time for them to do that, though, to do it well and to do it in a way that properly protects our rights and make sure we properly support our members in doing it. And so that is all happening in that time. It's not just sitting around collecting dust. A lot of work is happening on that case to make sure it is the best possible case to take to a board. And it's also having to happen while we're dealing with backlog cases and huge caseloads, right? So it's not just your case that's sitting on that hopper. It could be your case is one of many from your system division or federation, and a whole lot more from all of other system divisions and federations. And so that's all what goes into it. Within that arbitration process, each board will then have its own rules for how the case actually gets accepted or docketed. And so once that 9 months is over and that case is docketed to a specific board, then their own procedures will govern the timeline it takes. I can't speak to every one because, of course, PLBs, SBAs may have their own governing language. For the NRAB, for third division, there are specific instructions, and that's on the NMB website. You can take a look at Circular 1 and the NRAB instruction sheet for how these cases are handled. PLBs and SBAs, those would be written into the documents that authorize them in those agreements establishing the PLB or SBA. No matter what, if you have a question about that timeline, ask your general chairperson. They'll be able to tell you what rules are governing your case depending on which board it's in. Cases are generally going to be heard in the order they're docketed. There's not going to be any sort of like order of merit list on cases as presented, except for potentially dismissal cases. They have a chance to be pushed to the front because a dismissal, of course, is a big deal. If somebody is completely out of work, completely unable to, get any sort of compensation or any wages for their job. And so they may get pushed forward, but otherwise it's kind of first come, first served. If you're at the top of the pile, they're going to take you and they're going to work down the pile until they can't. When funding runs out to hear cases on the third division, hearings are suspended until funding gets restored or new funding becomes available. This chart may not be as easy to see on your screen, but it shows the general flow of how that works. NMB notification, it means that the union or the railroad informs the NMB that a case is moved into a status waiting to be assigned to a board. It's sort of on deck. Then it moves into an action list where no later than the first of the month before the case is heard, parties request that case to go to an active status. And that is when an arbitrator is requested and the board or division is designated for that case. Once an arbitrator is assigned in that action, then funding is obligated. So it all happens kind of concurrently there. Once all that happens, then no later than the 20th of the month before the case is to be heard, the arbitrators request that permission to hear and write up their assigned cases. And so it's a final sort of check to say, okay, we know I'm going to be doing this case. I know we've got funding for it. I'm requesting permission from the NMB to get this done next month. And then each month, the arbitrators receive approval to work on those active cases, and it's a month-by-month rotation. In that arbitration hearing, there are some boards that allow for certain things to happen, other boards, other things that are supposed to happen. Some boards do allow for evidence to be presented during the hearing through in-person testimony, but most boards, they're going to be doing all of their work on the submitted case file. Nothing new can be presented. And we'll have folks from the Mokina office that can help you understand some of the distinctions there because it can get pretty in the weeds. But know for the most part that if your case is going to arbitration, that case file is closed. You can't pop it open to add more stuff at the last minute. Your general chairperson is going to be able to advise you on whether the board hearing your case allows for additional testimony or evidence. Again, I can't say anything that's going to apply to every case in this webinar this evening. But we have that process, and that is leading us all to the award. And the award is the resolution of this entire process as established under the RLA. Under the RLA, once the arbitration board has a decision, the award, it is going to be final and binding on that dispute. There's not going to be an appeal from the board award. And as a minor dispute, that's where it stops. There is no sort of self-help. There is no strike or lockout or unilateral action allowed on that minor dispute once it's settled by the award. The award is determined jointly, remember. So all members of the board, the union member, the railroad member and the neutral arbitrator, they work as a team there. And so there may be rare instances where one member or another may submit a formal dissent to the award, or where they may request an official interpretation to clarify an award, but they all are intended to work as a team to get to that decision. When you look at an award, there are two flavors. It can either be sustained or denied. If sustained, the award spells out what the remedy is for claimants. And so inside the claim, we will request a specific remedy, but there may be times where the board determines a remedy that differs from the request. If it's denied, well, then the claim is denied, the remedy is denied, the case ends there. Part of all of this, and where I'm going to wrap up this presentation before we get to the Q&A, is that as union officers, as elected officers of our union, our officers have a duty of fair representation. What does that mean for arbitration? The DFR, it's a legal principle, and you're not going to find it in the RLA, but it comes through interpreting and applying the RLA within a whole lot of law. In the end, the U.S. Supreme Court decided in a decision in 1944 in a way that established the principle for how we interpret and apply DFR within the Railway Labor Act. And this was followed on by subsequent law and government policy that sort of refined that idea. And so if you want to look up the case that started DFR, it was Steel versus Louisville and NR company. I don't know what the Louisville and NR was, but it was a railroad. The federal law establishes the union as the exclusive bargaining representative for all employees. So RLA says, hey, if you're a union, you are the union, you represent all the employees in the bargaining union. This means the union, the elected officers must fairly represent all employees in the bargaining unit. They can't pick favorites. They can't discriminate. And so that means for case handling, claims, and grievance arbitration, the union must provide an equal and consistent level of representation to each employee in bargaining, in administering the contract and enforcing the contract through the claims and arbitration process. No union officer can choose not to do this process. They have to, unless, they are allowed to exercise discretion about the merits of a claim. If a claim is defective or deficient, or if there's just not enough info, they can say that. But all things being equal, they can't discriminate based off of whether somebody is in the bargaining unit, or if somebody's in the bargaining unit, they can't discriminate between whether they're one person or another person. The DFR, the duty of fair representation, is intended to prevent hostility or discrimination within a union and prevent arbitrary decision-making. And so the discretionary capacity your officers have occurs in good faith. It's them understanding how to interpret and apply the terms of the agreement in a way that protects your rights. That's the way their discretion operates within handling claims and grievances. In a nutshell, for arbitration work, DFR means that all members of the bargaining unit, unfortunately, they don't actually even have to technically be BMWED members, but they receive the same quality of representation within their bargaining group. Everybody gets the same treatment. What it does not mean is that every possible case has to go all the way to arbitration. That's, just not what DFR is. That's not what it means. DFR also does not prevent union officers from using their discretion in how they administer the agreement, right? They are empowered within the law and by election to administer the agreement, to protect members and to represent members. But they are allowed to use discretion within that. DFR just makes sure that they do it equally for everybody. So I threw a ton of information at you in this presentation. I don't expect you'll remember all of it, but here are some key takeaways. Disputes regarding our rights are minor disputes under the RLA. And so this is about applying and interpreting our provisions under our agreements. We can't go out on a wildcat strike for an overtime issue. It's a minor dispute. It goes through compulsory arbitration. We have a legally prescribed process to resolve these, including arbitration. Success in this process is not something that you can pass off to your fairy godmother. There is no sort of just handing it all to somebody else to do for us. A successful claim or grievance going from initial submission all the way to arbitration requires continuous input and support from all of us, all members of our union, at the lodge, at the System Federation, at Mokina, at National Division, all the way to it gets that award. There's no time where we just hand it off to anyone. Arbitration is the final stop for any claims and grievances that couldn't be resolved earlier in the process. A lot of disputes get resolved on property. They in the conference with your carrier officers, there's your elected union officers find a way to resolve the issue to the satisfaction of everyone. But where that can't happen, that's where the arbitration process finally resolves the issue. When we talk about arbitration, we need to remember that it is neutrally funded by the US government and part of the overall funding for what the NMB does as a whole. And so when we look at the National Mediation Board, it does a lot. Part of that is arbitration. In the third division, our claims and disputes that get arbitrated that way get a small slice of that overall funding. We are only one of several unions using this process in the NMB and NRAB to resolve claims and disputes. And so we have to understand that affects how many cases can be heard and affects the overall timeline for how cases can get processed through this system. NMB's arbitrators are well-regarded experts in the professionals in their fields. They can't be railroad employees. They can't be union officers. They can't be lawyers who are associated with unions or with railroads, and they can't be government employees. But they are well-regarded, often legal experts who have decided to take on the work of being an arbitrator. And they apply to do so and are assigned to the roster of arbitrators by the National Mediation Board. Our arbitration department supports the work of your general chairperson. They evaluate the submitted case files. They do the research on precedent, on issues with that particular dispute, and they will write the submissions for any cases that do get docketed to the appropriate board. Funding for the NMB and for the third division is a legislative issue, and I'll have Brother Cruzy on later to discuss that in greater detail. Advocating for more funding requires, if we want NMB to be able to hear more cases, we understand we need to do things through our legislative department to advocate for more funding. And so that means participating in our legislative department and our DRIVE program gives them the ammunition and the tools they can use to help us make that happen. The RLA and other precedents require our union to resolve minor disputes in this process. The process, if we want to change this process, requires changes to federal law. And so there is no easy out here to try to find some way to force anyone to do something different. Laws can change. We saw that the laws had to change for us to get what we have now. It took a lot of hard work, effort. It took a national railroad strike and a lot of violence to get to the RLA. And so we got to understand the scope of the issue we have. If we know we want to change the system, we can, but it's going to take work, creativity, commitment, and resilience. What can you take away from this? Knowing your agreement is the critical core to all of this. If we can know our agreements, we can protect them. We work by our agreements on the tracks. When we see violations to our agreements, we submit that information to our officers. They will work with us to write up the claims within the processes in your agreement to handle that. If they can't handle that on property, we're going to handle that all the way to the final award from arbitration. This is all part of defending the collective bargaining rights we have as union members. It's all of our duty to defend our rights, and we share that with each other. And that's what we're doing this evening with this presentation. If you want to know more, you can talk to the folks on our panel tonight, but you can also know your agreement, if you want to know which claims are currently in arbitration, you need to talk to your general chairperson. They're the best source of information on any current claims or grievances. You can contact them. If you don't already have their number, you can find it at our BMWED National Division website in the directory or by looking up our systems and federations. There's a link for it on the National Division website. If they're also the person you'd probably be the best position to ask about arbitration generally, because they understand not only the very, very big picture, but things specific to your federation, about arbitration, about the PLBs or SPAs you might be party to, about what the caseload has looked like, about recent awards or precedents. recent awards can be a big deal. They can affect you. And so it might be important for you to learn those from your general chairperson and share them at your lodge meetings. You can also go to the National Mediation Board themselves. They have a website, nmb.gov. And if you're really nerdy about this, you want to really dive deep, you can find resources there. Remember, this isn't just about arbitration, though. They'll be talking about PEBs, mediation, all sorts of other topics. So don't expect just a straightforward arbitration 101. They're going to go straight to the deep dive stuff that they do. You can also research prior arbitration awards at our national division website at bmw.org/arbitration. Now, that's a tricky thing. And remember, that sort of research, you may think you landed on something that sounds like it's a home run, but we have an entire department of hardworking folks who deal with this on a day-to-day basis, and they can help you navigate some of the issues with that. You can also find information about this presentation or other more general topics at our BMWED library. And so that will lead us to our Q&A. Just a reminder, no panelist in this event will be able to discuss specific claims or cases. So if you have a question about your specific issue, that's your general chairperson question, not a panelist question tonight. Apart from that, though, I'm going to end this slideshow. I'm going to stop share, and we will open up the floor to our panelists. What this means is that here soon, I am going to be giving you all the chance to unmute yourselves. That's going to be great. The one caveat is what I would ask you to do is use the react function or the raise hand function of your Zoom app or web browser to indicate if you have a question. That way I can give you a chance to unmute yourself when we're not stepping on each other. If that makes sense, that way we can have a good conversation without 5 people trying to talk at once. I will moderate that discussion and make sure we stay on track and timely. And so as I go through and set that up, my other panelists joining me this evening are, again, Brother Alex Cruzy, Brother Jay Suprenant, Brother John Schlissman, and Brother Zach Wood. And if you gentlemen all will give you a chance to introduce yourselves, I'd be glad to have you do so.
I'll lead off. Brother Jay Sprennett, thank you all for being here tonight, brothers and sisters, and in participating in this education event. As you all know, if you don't know, Jay Sprennett, I am the newly appointed Director of National Legislative Affairs. I'm one half of Brother Jeff Joins, taking over in D.C. here. With that, I'll pass it off to Cruzy, the other half of D.C.
Brothers and sisters, good evening. Pleasure to be on this call. I'm the Director of State Legislative Affairs, Alex Cruzy. I come off of BNSF, and before that, CPKC. This year, Brother Suprenant and I had done a lot of work on the National Mediation Board funding and how that works at the legislative level. And so if you guys have any specific questions regarding how we kind of put ourselves in the legislative process to receive funding, to argue that we need more funding, you can direct it towards one of us, and we'll be sure to answer them.
Alrighty, I'm John Schlisman. I'm the National Road Adjustment Board 3rd Division member for the BMWE. I'm here to just answer any questions you might have about the arbitration process, how it works in the general way. We also have Adam Gilmore, it looks like, and that's all I have. So I look forward to talking with everybody. Thank you.
Hey, good evening, everyone. My name is Zach Wood. I'm the Director of Strategic Coordination and Research. Prior to taking this role, I worked in the arbitration department for approximately 6 years. My job function now, I still interact with the arbitration department on a weekly basis, and then anything that goes to the National Mediation Board in regards to in regards to mediation, and then eventually a presidential emergency board, I handle all of that as well.
And Brother Adam, if you could introduce yourself. I snuck you on as a panelist.
Yeah, Adam Gilmore. I'm the Assistant Director of Arbitration. I work with John. I worked closely with Zach when he was in our office. Happy to help.
All right. And so the first hand I see raised is Jen's phone. So go ahead and what question do you have?
Hi, my name's Joel Crane. I got a claim that I put in, and it's been probably 6, 7 years ago, but I drove lowboy out of Denver, Colorado, and they got rid of half the fleet, but still had contractors doing everything we were doing. And I got everything submitted. I mean, the case was ironclad. They won it. And now it just sits in limbo and nothing has happened for years. And I'm not getting a whole lot of feedback. They're saying they're going to court, they're not going to court, it's being held. It's, I'm real curious of why.
The last piece that was heard was that when they were supposed to, when it was sustained and then the 3 members come and determine the award, I believe the railroad did not come. And so they resubmitted something again a year later, this past February. So what is that process and why would something like that happen?
I can answer that question. So I believe you're talking about the awards that came out on PLB 7661, which was Union Pacific and the lowboy cases. Is that correct?
Yes.
Yeah.
Well, okay. So now we don't want to get into too much detail about specific cases, but to speak, because I don't want to, I do have some knowledge of the specific case, but again, I don't want to get into a whole lot of detail regarding specific cases. But on a general level, what can happen sometimes is after we get a sustained award, sometimes the carrier can kind of dig their feet in and say, well, yes, the award is sustained, but we're contesting the remedy. And when they contest the remedy, we have a couple of different options. We can either sue for enforcement in the district court, or we could proceed to an interpretation. So what often happens, and what happens in this case, I believe, is that we sued for interpretation, we sued for enforcement in the district court, and then the district court looks at the case and they say, well, if there's any issue here that needs to be interpreted, it's a minor dispute, and it has to be basically kicked back to the arbitrator for interpretation. And then what often will happen is the award will get sent back to the arbitrator, at which point the arbitrator has to interpret the remedy portion of the award. So that way the parties have guidance on how to pay out the award. So the award can't be paid out until it's decided how to pay the claimants out. And if there's some ambiguity with respect to the remedy requested, that can be a challenging process. So that's not always the case. You're kind of in a unique circumstance, I believe. But in cases where you have long ongoing agreement violations that are of a continuing nature, sometimes it can be very difficult to determine the remedy. And that is probably where you are sitting with your case.
Well, thank you for this. I really appreciate just the education. I just was saying the other day, the communication is the biggest piece that is, I feel we need to understand. So thank you.
You're welcome.
I have Brother Rodney Stone. Go ahead.
Yeah, hi, Ash. Rodney Stone, Lodge 0212. I just had a question about the arbitrators. Earlier, you said that they are regarded as experts in their field, but then immediately after, you said they can't belong to a union, they can't belong to the railroad, they can't work for a law firm that represents, I guess, either parties. I'm just kind of curious how they could be experts in their fields if they're not allowed to belong to any of those organizations. Are these arbitrators, do they have like past, or in their past, did they belong to a union? Just kind of curious about that.
Yeah, I mean,
I'll field
oh,
I'll field that question. Oh, sorry, John. Did you want to field that?
either way is fine with me, Zach. You go for it. Go for it.
Yeah, so there's look, as Brother Ash had mentioned in regards to being experts in their field, most of the arbitrators have a legal background. Now I will say this, just for perfect clarity, what he means by they can't be part of a union and can't work for a railroad, that means currently, right? So there are arbitrators out there that have been on the union side and have been also employed by carriers in the past, right? But in regards to experts in their field, typically that means that they're experts in the legal field. They've practiced various different practices in not just railroad arbitration, right, but also in other industries such as steel, and as even, you know, there's arbitrators who have done arbitrations for the MLB and the NFL, right? So it's really being a matter of being an expert in interpreting contract language and what that means and how to apply it to everyday standards. John, if you have anything to add, please feel free to jump in on that.
No, yeah, that was a great explanation, Zach. And I would also emphasize that, I mean, we really are dealing in a lot of cases with the cream of the crop here. I mean, these are really good arbitrators who are at the pinnacle of their careers in a lot of circumstances. And they are experts at reading an agreement and determining what that agreement means and whether or not the agreement was violated. And like Zach said, some of them do have practical experience as far as being members of a union previously, or being maybe a general chairman previously. Some of them have experience with the carriers. Some of them are just lawyers who have made it their life's work to be involved in alternative dispute resolution. But we do have some very, very good arbitrators on that NMB roster who are deciding these cases. That's all.
Okay, thank you.
Sure.
We do have a question from the chat. Cameron Worth asks, so on a dismissal case, it could not be chosen to be heard in arbitration. And so maybe I wasn't super clear on that. If my panelists could clarify, when it comes to dismissal cases, what does that mean for them? When we talk about, basically, I think when I was saying that in cases for arbitration, they go in the order listed, but dismissal cases could be moved ahead. But the one thing I would offer, Cameron, is that your dismissal case may get resolved prior to going to arbitration. That's also a potential there. But any other panelists' input on there would be welcome.
Yeah, I mean, we take the vast majority of dismissal cases, for sure, to arbitration if it doesn't get settled beforehand. And like you said, Ash, typically if we can move the dismissals ahead of the line, we do so because we want to get those people back to work as soon as possible.
I guess maybe to clear up a potential hypothetical, if we're looking at an investigation transcript, and this is an extreme, and let's say the guy is, you know, on record saying I did it and I would do it again. He's got a history of doing this, you know, whatever he's accused of multiple times, and he's already on a last chance waiver. If that dismissal were to come to us, we might look at that and recommend that we don't progress that. So I don't know if maybe that's a hypothetical scenario that maybe you were thinking of, but even in that case, that person would still have the option to progress their case on their own. And that's kind of an extreme example. We take dismissal very seriously.
Cameron, would you like to talk about that more over voice, or is that pretty solid for you?
That's pretty solid for me. Thanks, y'all.
No problem. Thank you. All right, right now, so I did get a Q&A question about how do we find where we are at on a list for arbitration. Again, if you have a specific case that you know is getting currently handled, you need to talk to your general chairperson. They're going to be the best person to ask about where your case is. I don't think that anyone here would be able to grab that info for you. But other than that, we have an open floor. Seeing a bit of open floor time here. If you do have a question, go ahead and raise your hand in the reaction or raise hand function. But I do have Brother Cruzy and Brother Suprenant here from the DC office who can maybe elaborate a little bit on the latest and greatest with the funding piece of NMB arbitration. If you brothers want to go ahead.
Sure, I can give a little update on that. This year, the National Mediation Board issued their congressional justification in April, and that congressional justification is basically what they project their budget to be and what they are asking Congress for fiscal year 27, which would run from October to October. That budget included basically a self-imposed cut, as Brother Ash showed on his presentation. In 26, they were funded at a level of $15.113 million for the entire National Mediation Board. This year, the National Mediation Board requested $14.3 million, in self-imposed cut of about $800,000. That $800,000 was going to be equally shared as a cut in both the arbitration services, the mediation services, and the representation services portion of the NMB budget. We were not satisfied with that because, as Brother Ash mentioned, we have seen an increase in backlog cases at the National Mediation Board, our arbitration cases. And we, in the legislative department, we were basically tasked with how can we resolve this issue? How can we either receive more money for NMB that they can put specifically towards arbitrator salary and expense, or how can we just get more funding overall for NMB and then they can divvy it up how they need to? It was clear from our discussions that they're on Capitol Hill, a lot of people were unfamiliar with our arbitration process and how it is funded. Historically, the NMB was just receiving a blanket amount of money, and then the NMB itself was divvying up how that was being spent inside of their departments. In May and in June, we saw that the Labor, Health, and Human Services subcommittee of the House of Representatives did a markup of the appropriations bill, which would include funding for National Mediation Board. Prior to that markup, Brother Jay Suprenant and myself, and Brother Jeff Joins, Brother Alex Beckman from Teamsters Route Conference, we had dozens of meetings with people that sit on that subcommittee to educate them about how our arbitration process works, how it's funded, and how basically an increase in funding specifically towards arbitrator salary and expense is important to reduce the backlog of cases and speed up the process at which our cases are heard at the board. That markup was completed at the beginning of June. When that markup came out, when they were actually going through the bill, to our surprise, and I would say it is a huge victory on behalf of the Brotherhood of Maintenance Away, we got the amount of money restored to the National Mediation Board, that additional $807,000 to be flat funded with last year's funding, and in conversations with the National Mediation Board and with the committee's report that comes out with the appropriations bill. That report stated that they recognize that there is a backlog of cases at the NMB and that they are basically saying that that additional $807,000 should be added to the NMB's arbitrator salary and expense portion of their budget, which would take it from what they requested at $900,000 to $1.7 million, essentially doubling the amount of caseload that they will be able to hear for fiscal year 27. Fast forward, that appropriations bill needs to be considered by the entire House of Representatives, and then the Senate will also take on its own appropriations bill, and both of those will have to be identical bills before they get passed on to the president to be signed. But as I said, that the House Labor H subcommittee that handled that language even put in their report that they recognize the backlog of cases and that they want to see a reduction in the backlog of cases. That is a huge step forward for us. And as far as advocacy goes, like I said, we've had dozens of meetings explaining our process to legislators. And if Jace wants to add anything else, I'll let him.
No, absolutely. To pair on what Brother Cruzy said, don't let him humble you. He actually led the charge on this and has done an amazing job. And when he says dozens of meetings, it's not that. It's more than that. He worked his butt off up on the Hill. So, Brother Beckman and I have joined him on some of these meetings, but he's taken the lead on this and really got the awareness out and getting the offices to know really what's going on. So, Like you said, it's an ongoing fight here. We're not done yet. We're going to keep on going with this. We're going to get to the floor, and then it's going to be a whole nother fight again with the Senate. So, I just, like I said, I just don't let him humble you. He's kicking ass on this.
All right. Thank you, brothers. A couple more questions. One came up in the Q&A. Travis asks, what does it mean on a claim when you look online and it says sent to Chicago and check status? Travis, if you want to unmute yourself and explain a little bit more about that, I think I know what you're going for, though. Before I got this position, before I worked at National Vision, I worked at the Burlington System Division, and I did a lot of work helping administer the claims and grievances that the Burlington System Division processed. And inside our systems for doing that, each system division federation kind of has their own system for managing the caseload, and they'll have their own way of putting in notes about where stuff is. And so when you see notes like that, where it says sent to Chicago or check status, that's probably a note that generated from your system division or federation level about where the case is in their own handling. And so I would say that's probably what that means. And you should ask your general chairperson for more clarification on what that means, because it could be something that they have, and it could be a docketed case or it could be a submitted case, but your general chairperson will know what specifically sent to Chicago or check status are in that system that's set up. So if any of my panelists have any other input there, but that's the way I would go for that one, Travis.
That sounds about right to me. I mean, I feel like I'm pretty familiar with like the ins and outs of our like internal system, and that's not like a code or a term that we would see. So it sounds like it's on the Federation side.
Yeah. I think I saw similar stuff on the system division side when I was at that level. Stephen Jarman asks in the chat, will the slideshow portion of the presentation be available to view later? It will. It takes me a couple of days to get this recording up on our YouTube channel and on the website. But even after that, the actual slide deck itself, I might do a little bit of last minute polishing on it, create a PDF file that then I'll post in our library. And so if you want to bring that information to your system or your lodge, or just share with fellow members, you'll be able to. If that information in that slide deck gets a little bit stale, some of that's timely information. If it gets out of date, I may pop the hood and try to update that, or I may pull it and replace it with something else, but it should be there, I would say, next week. So any other questions for our panelists? All right. It looks like I'm either answering everybody's questions or I'm creating such a problem they don't want to ask. Well, thank you, Brother Evan. I would love to give the last word to my panelists this evening, since you guys are the ones who do most of this work. So any last thoughts that you have for our participants tonight about this process? I'll pick on you first. Go ahead.
Thanks for having us on, and also to all the members on here, just stay engaged. And I know it's hard sometimes, but on behalf of the arbitration guys that are doing this work, I can honestly say patience is a virtue. And these guys work day in and day out and are putting in a lot of hours to try to get the best resolution on claims that they can. So know that somebody's out there fighting for you, even when it feels like it's not happening. It is happening. I promise that.
Absolutely. To echo Brother Zach there, just anytime you have any questions or concerns and involving what's going on up here on the Hill, feel free to reach out. I just threw my name in the chat there, my phone number. That's my personal. Call me anytime if you guys have any questions. I'm open to everything. And again, thank you all for being here.
I'd also add on that, I put my information in the chat as well. When it comes to NMB and legislative work and how that operates, feel free to reach out. Jason and I, if we don't know that answer, we'll direct you to the right place. Huge props to our arbitration department. They get a lot of cases. They filter through a ton of them all of the time. They did not say this on the call, but as far as getting favorable awards, we are leading the way as far as rail labor. We have a higher success rate than any other rail labor union. So that's a huge shout out to them.
Any word from John or Adam?
Yeah, I'll just say thank you everybody for coming to hear the presentation today. I think Ash, you did an amazing job going over a difficult topic, and I'm sure it was beneficial for everybody who was here to learn about this issue, and please take what you've learned today and talk to other people who you work with, so that other people know what's going on and how important arbitration and what we're doing as a brotherhood is, with respect to the legislative department and arbitration and national division. Everything kind of like works together, and just communicate that to everybody. And great, thank you, great job everybody. So thanks, that's all I have.
Yeah, just thanks for having us. And then a personal plea that I'll always say: if your representative asks you for a statement or for evidence, make sure you get it to them. It makes my job so much easier. It makes John's job so much easier. Help each other write the claims, help each other get the evidence, take the pictures of the contractors, everything you got to do.
All right. I want to thank you all for joining us this evening, and thanks to our panelists for sharing what things look like from their end. If you have any more questions or concerns about this presentation or other educational department stuff, reach out to me, education@bmw.org. I'll find the tools for you. The one thing I'll ask is, if you did learn something tonight, don't keep it in your pocket. Share it with your fellow members. I don't want to see our National Division Facebook where people are attributing arbitration issues to the Railroad Retirement Board. That makes me feel bad. So other than that, stay safe out there. Have a good night, and I will catch you down the way.